Thank you for listening me. My name is Korat and I'm going to speak to you about corporation law, Australian Security and Investment Commission versus Parker. Uh, with my fellow mates, Sapna, Yohana, Sajana and Sunita, beginning with the introduction on our topic, then continuing with fact of case, duty of the director under corporation law, section in issue the case, impact of decision over the operation of the company in Australia would be further explained deeply in the presentation. Starting with the overview, ASIC has undertaken corporation law duty for economic interests of Australian public. It acts constantly to find the violator of the Corporation Act and who remain silent. It constantly works for the find, the projection and enforcement of the corporation law by the corporation. For an example, the Vigilance Act of ASIC brought the director of the Queensland Superannuation Private Limited before court on finding the truth that he breached the duty and was silent. The case was like there were allegations made against the director of the Queensland Superannuation Private Limited that he proved the loan amount 2.5 million to Mr. Pradue on July 1997, which had to be approved after independent verification of financial conditions prescribed for approval of loan by the company. The director of the company were responsible for granting and approving the loan in the company. However, the defense director approved for granting and approving the loan company. However, the defense director approved himself the loan without checking the requirements set for the loan approval above that he breached the express duty given to him to check background and history of the person who is asking for the loan from the company. In spite, the director grossly approved the loan and did not went to checking whether the person seeking loan has taken loan previously or not, whether he paid his all previous loan and timely basis or not. Further, my friend Sapna would explain you the duty of director under corporation law. Thank you.
Hi, my name is Sapna. Today I am going to explain the duty of directors of under corporation law. Section 181, director has to be seen that power is exercised to subservice interest of company in good faith and restriction on improper of position as per section 182. Section 191 provides imposition of duty of disclosing personal interest. And today also discuss about section 180. Section 180 require almost good faith by the director of the company if the act of the director comes in contravention with the interest of the business, then such act will amount to breach of legal duty and violation of corporation law. Also, we discuss section 181. It provides for fulfillment to avoid the civil liability by the director of the company. They must use their position only for proper business function only. There must not be any mala fide intention behind the exercise of power and discharge of duty by directors. The director will not use their position to secure personal interest on the interest of third person in whom they have interest. Section 182 asks the director to use the business information and secrets for the business purpose only. And if any personal interest arise in the decision making of which director is involved, he must tell the same to the other directors. Thank you.
Hello, I am Sajana. I am talking about section in issues in the cases. There are three sections here, that is section 181, 191 and 232. Talking about section 181, duty to act in good faith and to serve the interest of the company, non-performance of independent verification before approving loan. And section 191, duty to disclose personal interest if any involved, expressly stating the personal interest to other directors that behind approving loan success fee is the reason. Talking about section 132, the power of the court to decide the case and validity of action of the directors. Approval of lien without independent verification violated section 181-191 of the corporation law. The director to fulfill own profit motto forget the duties under the corporation law. He also hides such interest for the stakeholders of the company. Now I want to talk about decision of the case. Court found failure of the directors to examine verification of benchmark of 80% and expense ratio at not more than 45%. The value submitted by Taylor Burney valuers to Board of QLC Superannuation Private Limited, assets and value land, cost of refit and relate and income held. Obtaining true profit and loss account for accountant directors of the company, the court barred the dependent directors from corporation for the term of 4 years. The court found that the board of directors of the company made breach of his duty by gross approval of loan to Mr. Perdio of 2.5 million, and therefore it prohibited the defendant directors from corporation for the term of the 4 years. Thank you.
Alright guys, today I'm going to discuss about the analysis of decisions of the case. So decision of court is correct and based on sound balance of interest of company and the applicable sections that has been discussed previously. So in this case, the director's guilty was evident from the involvement of him in the success fee of loan approval. It means that directors did not act as per his duty in the corporation law. Therefore, the court enforced his duty by making him disqualified for the next 4 years. The next is about the relevance of decision of development of corporation law. Decision of ASIC versus Parker was one of the examples of effective enforcement of applicable laws over companies. The vigilance and seriousness of Australian Securities and Investment Commissions, or ASICs, about its duty under the corporation law will act as threat for the subsequent violators of the corporations. Because of that, it will have deterrence effect for the peers companies for compliance of legal duties. So the next is going to be discussed by the Sunita. Thank you.
This is Miss Sunita. Today I'm going to talk about the impact of decision over the operation of the companies in Australia. And this decision, we're going to talk about the two impacts, that is the positive and the negative one. And the positive one, the positive impact includes attention towards the compliance of legal formalities in all the activities of the business and less litigation consequences for the violation on various occasions. In similar way, in negative impact, it will include that the corporation will go for finding the other ways in which they can run their business without direct violation of the corporation law liabilities, and adverse impact over goals of company and result out of that. And now in conclusion, we can add that all the duties, whether they pertain to administrative nature or in relation to any other function of the business, must be carried out in bona fide faith only. Also, the non-compliance of the corporation law have the consequences of the pecuniary and punitive nature as well. Along with that, being on the prestigious position in the organization, directors should exercise each and every act should be dedicated to the interests of the corporation. So, in the summary, I can conclude that duties in relation to function of the business must be carried out in bona fide faith. Only as non-compliance will have the consequences of the pecuniary and punitive nature as well. Thank you.